Michael Roberts seems to have been around on the list for a long time. He practiced as a solicitor with what was then Arthur Robinson Hedderwick's in the area of commercial litigation, specialising, I think, in intellectual property then, and was responsible for a large number of large-scale, when I say responsible, he was responsible for the conduct of a large number of intellectual property disputes in all courts. Since coming to the bar, Michael has practiced almost exclusively in commercial and construction law. It's construction law that I've been opposed and worked with him, and he's developed a substantial practice in that area, and it's that area, of course, which has given rise probably most often to issues in relation to the proportionate liability provisions, and so his experience will be valuable. Thank you, Michael.
Thank you. Good morning, everybody. Listening to what Kyle has been saying over the last half an hour or so, you may well have formed the view, and I think the view is right, that the breadth of this Act is, and the sort of proceedings to which this Act applies is very broad. For what it's worth, I agree with that view, but there's a decision of the Victorian Supreme Court, the Court of Appeal last year in a case called Quinertz that I'm going to take you to, which on one view actually makes the scope of the Act very narrow. But I would encourage people to take a very expansive view to the potential operation of the Act, because if you don't, the risk you run is that cases that are apportionable, you'll come to court and find that you haven't joined the appropriate parties, you haven't pleaded the proper causes of action, and you may end up in a position, as happened in a case called Sarli, where at the moment I believe it's before the Court of Appeal, where somebody thought they were suing the party that was 100% responsible. You weren't involved in that, were you? Oh, good. And ultimately what's happened is that the person that they thought was 100% responsible only got 30% of their damages against. So that whereas, and the problem there is that they hadn't joined the party that was 70% responsible, and the result in only getting an award against the party they wanted to get the award against for 30%. And that's currently before the Court of Appeal, as I understand it, so that's a matter that's still under advisement. The other point that I'd seek to urge upon all of you here, and I find it remarkable how often you still hear it, and I hear it from large firms who say it, that if you have if a pleading in contract, the contract for the sale of goods, the contract, I've got a case at the moment, contract for the sale of some trucks, they say it's not a case that the apportionment legislation applies to. Now, one of the reasons why I got Kyle to put into the paper the reference to Justice Pagoni's decision in Solac, and if you put that into Ostley or LexisNexis, you'll find it's been referred to a lot, that this notion that if you plead something as a breach of a contract for the sale of goods or a breach of a contract for the sale of something like a truck, people say, well, there's no assertion of a failure to take reasonable care, so therefore it's not apportionable. Well, with respect to the people who have that view, they're just plainly wrong. And Justice Middleton's decision in Dartburg makes it very plain that even if you don't mention the words failure to take reasonable care anywhere in the pleading, it comes down to what the evidence comes out at trial. So that people who think they can say, and you've confronted it in a mediation context, I sued you because it's a contract for the sale of goods. I'm not interested that you say there's some subcontractors who contributed to the problem. You deal with them. My claim is against you. I settle with you. To give you a further example, I was involved in a case before Justice Davies 2 or 3 months ago, and it's a good example actually. A company sued my client on a contractual basis because my client provided that company a product, and the product was, on the evidence, defective. The fact of the matter was that my client was merely a go-through person. My client actually had done nothing to manufacture that product. There were 2 subcontractors who had been involved in the manufacture of that product that was then supplied to my client in the finished form, who then supplied it to the ultimate client. Client sued my client, being the supplier of the product, saying contract for the sale of goods. Didn't bother suing the 2 specialist subcontractors who had provided the individual services to make that good. I then appeared before initially Justice Judd and said, well, hang on a minute, even if that's right, even if they are defective, they know that there were 2 subcontractors who were involved in manufacturing that good, and those subcontractors owe a duty of care to the ultimate client. Now, obviously, we all know there are High Court decisions about whether or not subcontractors owe duties of care to ultimate clients, and I'm not here telling you that in every circumstance a subcontractor owes a duty of care to ultimate clients. But in this instance, ultimately people accepted that the proposition was that these subcontractors at least arguably owed a duty of care to the ultimate client. Consequence being that you had a situation where everybody basically accepted that the good was defective and that the plaintiff had a good cause of action. But from my client's point of view, it meant that we had the ability to be able to settle the case on far more advantageous terms than otherwise in the old days you would have been able to, because we were able to say, well, even if you have a good cause of action, even if you're 100% right these goods are defective, all my client was the go-through person. So therefore I was able to say to these subcontractors and to the ultimate client, you deal with them, not with me. So that's a very good example of what David was talking about, that it may well be insurers are involved in this case, as often is the situation, where insurers and other institutional clients have been able to take advantage of Part 4AA to be able to negotiate a far better settlement or negotiate a far better position than in the old days, where in that case, quite classically, it would have been, no, we're just suing you, you supplied the goods, you deal with them. And so that's a very good example of where you need to bear in mind that, and that's why Justice Pagoni's decision in the Solak case is of prime importance for people to be aware of, that even though you've got a contract claim, Part 4AA will have an application, especially in circumstances where you're talking about the sale of goods, etc., because if the good is defective, it's very easy to conceive of an allegation or a proposition where there's a failure to take reasonable care. Now, I mentioned the Court of Appeal decision, and I really think, and I'm genuine in saying this, that everybody who works in commercial litigation must read St George Bank against Quinnertz. There's a reference to it in the paper, because in listening to what Kyle and I have been saying, you may well have got the view that the proposition that Part 4AA applies broadly to litigation is the position under this Act. And indeed, if you read, in my view, if you read the various introductory statements made in respect of both this Act as well as the amendments to the Trade Practices Act, the intention was, in a very simplistic way, to say there are 5 people involved in this breach. They're all 20% responsible in a very simplistic way. Therefore, each of them pay 20%. But what the Court of Appeal has done in St George Bank is to actually say that the operation of Part 4AA, on one view, is very limited. Briefly, the facts of St George Bank were these: that St George Bank retained the services of Quinnertz, who was a valuer, and that for the purposes of working out the value of a property that they were then going to lend some money to a borrower. Quinnertz valued the property that ultimately turned out to be worth about $500,000 negligently, as the evidence turned out, and valued the property at a figure of $800,000. And then, on the basis of the back of that valuation, St George Bank advanced money in advance of the true value of the property to the borrower. Time goes by, the borrower pays their money under the facility for a period of time, but then ultimately the borrower, unfortunately, defaults, doesn't pay its loan, and the bank then says, well, hang on a minute, we'll sell the property, we'll get our money back, and then finds out they don't. Before the county court, they then sue the Quinnertz, the valuer, and say, well, your valuation was negligent, and at the same time they also sue the borrower saying, you owe us the money. Quinnertz said, well, hang on a minute, well, we may well have been negligent, but the loss that you suffered, which is the loss on not getting the money paid back, is the same loss that the borrower hasn't paid, and so therefore it's an apportionable claim. You get some money against the borrower and some money against my client, being the valuer. Now, and it seems to me that on first blush that's a reasonable argument, namely the bank is in the position it's in because 2 people did the wrong thing, and 2 people did the wrong thing in the sense of a failure to take reasonable care, namely the valuer first got his valuation wrong, and then subsequently the borrower didn't pay his loan. Interestingly, in this case, nobody suggested that a borrower failing to repay their loan didn't involve a suggestion of a failure to take reasonable care. The focus was on whether or not the damage we were talking about was the same damage. So it's not so much a question of not an apportionable claim, and I come back to what I said earlier about the need to be very broad in what constitutes a failure to take reasonable care, but rather it was decided on the basis that the damage that we're talking about here was not the same damage. Now, and to illustrate that point, and I've got the judgment in front of me, if I can, and I do encourage people to read this and very carefully consider what it says. For instance, at paragraph 76 of Justice Nettle's decision, and in making reference to this, I would encourage people to, in appropriate cases, to not necessarily, well, with due respect to the Court of Appeal, not necessarily simply accept it as reflecting the appropriate law if you have an opportunity to go back before the Court of Appeal and seek to persuade them, and perhaps they went a bit too far in saying what they've just said. But at the moment, in all cases, this is the Court of Appeal talking, so it must be complied with. So, talking about the issue of the borrower and the guarantor, at paragraph 76, the Court said, "I do not consider the borrower or the guarantor in this case could be said to have caused or be liable for the same damage as Qunertz. The loss or damage caused by the borrower and the guarantor was their failure to repay the loan. Nothing which Qunertz did or failed to do caused the borrower or the lender to fail to repay the loan." So here we have a situation where there's a temporal disconnect between the failure on the part of the valuer and the failure on the part of the borrower. Namely, the valuer made the mistake at the start and the borrower failed to repay at a future point in time. The damage caused by Qunertz was to cause the bank to accept inadequate security from which to recover the amount of the loan. Nothing which the borrower or the lender did or failed to do caused the bank to accept inadequate security for the loan. Furthermore, just as in another case, the distinct nature of the damage caused by Qunertz is demonstrated by the need to establish the damage which the bank would have suffered if Qunertz had not acted negligently in the preparation of the valuation, and then to calculate the difference between that and the damage which the bank has suffered by reason of the borrower's and the guarantor's failure to repay the loan. So the point that I'm making here is that whereas on first blush you'd say the reason the bank's in this position is twofold, namely the valuer made a mistake and the borrower didn't repay, what the court's saying is, no, you can't be that simple about it. You've got to think about what is the actual damage that flows from the failure to take reasonable care. Here it's saying, here the case is saying that the loss that flows from the valuer is if the valuer had valued the property properly, it may well be the bank may have given a bit more money. It would have given less, but it may have given a bit more than the amount that they ultimately lost. So the situation, whereas with the borrower, it's very easy to calculate. There's a loan document, and they obviously haven't paid the amount they due under the loan. So, and whilst the Court of Appeal was talking about a very specific circumstance, the need to show the fact that the damage that's been suffered is the same damage, not just that both parties are involved in the breach that results in the loss, is emphasised again at paragraph 85 of the judgment, where the court said that the point was that for the lender's negligence and the valuer's negligence, the loan would not have been made. It followed that the lender's negligence in making the loan caused the same damage as was caused by the valuer's negligence in permitting the lender to make the loan. Here it is different. Although Qunertz's negligence caused the bank to make the loan, or at least caused it to lend more than it would otherwise have been prepared to lend, neither the borrower nor the guarantor did or failed to do anything actionable in the sense of rendering them liable to the bank, which caused the bank to lend or to lend more than it would otherwise have been prepared to lend. On the facts of this case, the only actionable acts and omissions of the borrower and the guarantors were their failures to repay the loan, and axiomatically their failures to repay the loan did not cause the bank to make the loan or to lend more than it would otherwise have been prepared to lend. So the point that I'm making, that's another point along the same lines where Justice Nettle is saying that you must carefully consider as to whether or not the actions that you're complaining about caused the same damage. Not that they resulted in the same consequence, but they caused the same damage. So, and that decision, I reckon it's not readily approachable with due respect to the court. I do say that you need to be very careful to read it, because You shouldn't be telling clients, and it impacts on everything I'm about to say about the other points I want to make. You shouldn't be telling clients, oh, this is obviously an apportionable claim, or this is obviously not an apportionable claim, because applying what the Court of Appeal has said here, any given fact situation is not free from great complexity. So with that in mind, we then approach the issue of settlement and Part 4AA. Now, often in court, as counsel, you confront judges saying, well, why can't you settle this case? And as David's referred to, you readily have courts saying, well, you can settle with that party, being defendant number one, and then you can deal with the other two defendants as you see fit if they're being difficult about it or they're being intransigent. The difficulty with that proposition is this. Firstly, if the case is one that involves the apportionment legislation, then, as Justice Burns says, that in the appropriate circumstance you can come up with some kind of settlement with one defendant where you settle with them, take an amount that you want to settle from them. You have to get judgment against them to make sure that the position is that you get judgment for the proportion that you say you're entitled to. But then you've got to still deal with the other defendants. Problem with that is that if the Act doesn't apply, then you've settled on the basis that a proportion of the judgment is recoverable against defendant number one. If the Act doesn't apply, you may well have impacted upon your ability to recover against the other two. If the Act does apply, you then may well have a situation where you may have not settled for an appropriate figure. You may have, the other two defendants will then be saying, well, in fact, the defendant they've settled with is the defendant that will have been responsible for the lion's share. You may have taken 25% against defendant number one. Defendants 2 and 3 may say, well, in fact, the appropriate proportion against that defendant number one is 80%, so therefore it doesn't matter they've only got 25% of their loss and damage against defendant number one. It really should have been 80%. We're both in the gun for 10%, and your client's in the position where ultimately they fall between two stools. The consequence of that is that from my experience so far, and this both relates to Section 131 as well as Part 4AA, trying to settle cases where you settle with one defendant and continue against the rest is very problematic, and it's very hard to set any hard and fast rules that result in giving you guidance as to in what circumstances you settle and how you settle. The corollary of that is that other than in very specific circumstances, it's very difficult to make an effective call-to-bank offer. The rules of court don't permit of a very simple offer of compromise regime. Call-to-bank offers can be done. They usually involve, as an example of the case I was involved in involving product liability, that I mentioned that was involved in a few months ago, they usually involve a situation where the defendant who recognises they may well bear the lion's share may well be prepared to pay out the entirety of the claim on the basis that they will then pursue the other solvent defendants for contribution. That sort of offer can be made, but in making that offer, the defendant making that offer needs to understand that it is then taking the risk of solvency of the rest of the defendants. And that, in certain circumstances, there's no problem because everybody knows everybody's insured. But if people aren't insured, be alive to the fact that if you do make that sort of call-to-bank offer and it's accepted, the consequence will be that your client, being the defendant, will be taking the risk in relation to the solvency of the defendants. And if it turns out that in making a subsequent claim effectively for contribution, which it can then do, the problem will be that if contribution is against defendant number 2 or defendant number 3 and they're insolvent, the risk of insolvency passes from the plaintiff to your client. So that's the reason why settling proceedings, people coming this morning might be saying, give me some guidance as to how I settle a claim that Part 4A applies to. Unfortunately, in general, that guidance can't be given because it's a very fact-specific consideration. Moving on, I don't make an the issues involved in Part 4AA are very complex. It's very difficult in the time available to give a detailed guidance on every issue. So what I'm endeavouring to do is to give you some guidance on a few points that I think are important. One of them is the issue of pleading requirements. Now, still, even after 5 or 6 years of this Act being completely in vogue, you still encounter regularly in pleadings a misconception, both as Kyle referred to, that to invoke Part 4AA, you only need to talk about the duty of care in a contractual nexus between, for instance, a subcontractor and head contractor, when in fact the focus must be that if you want to invoke Part 4AA in a pleading, you must identify, acting for the defendant. If you say there's another person who's responsible in a Part 4AA sense, you must say they must be first responsible in a legal sense to the plaintiff, and you must identify that legal responsibility in your pleading. So that in relation to a simple fact scenario is the concept of a head contractor, principal, head contractor, subcontractor. Head contractor, and there's a problem with what the subcontractor did. Putting aside the issue whether or not that subcontractor owes a duty of care, you acting on behalf of the head contractor say you have to be joined. What your pleading must first identify in a defence and counterclaim, which I'll come to in a minute, is the cause of action that the plaintiff has against that subcontractor, as though you were acting for the plaintiff. So that, as Justice Hollingworth identified in Cowan and Greater X and her decision, and there's other decisions to the same effect, the way to properly invoke Part 4AA to acting for a defendant in the first instance is to plead a defence and counterclaim. This is the way I do it. You plead a defence and counterclaim, and the plaintiff is made a defendant to counterclaim. Not because you're seeking damage against the plaintiff, but what you're involving the plaintiff in is requiring them to respond to the matters you identify that you rely upon for Part 4AA purposes. So what you do in your counterclaim is, after setting out your defence to the main claim made against your client, is you then in a counterclaim set out the claims that the plaintiff has against Defendant 2 and Defendant 3. And then at the end of the counterclaim, so that, for instance, in a building case again, you would say, in respect of a brick subcontractor that caused a problem with the brickwork, you would say that subcontractor owed a duty of care to the plaintiff. Don't worry about your client, the plaintiff. And in breach of that duty of care, it did the following things, which caused loss and damage to the plaintiff. And then at the end of the counterclaim, you add in anything else you want to say against the plaintiff if there is an issue. At the end of the counterclaim, you then claim declaratory relief, saying that in the circumstances this is a claim to which Part 4AA applies to, and you then seek an order that there be an apportionment of damages as between the people involved as concurrent wrongdoers. Now, the benefit of doing that, as Justice Hollingworth identifies, and there are other cases, the benefit of doing that is it forces the plaintiff to say whether or not they agree that the proceeding is an apportionable claim. And if they say it's not an apportionable claim, for instance, if they want to say it's a contractual claim that doesn't involve an allegation of failure to take reasonable care, then they can identify that fact. And the beauty of that is that then at an early stage allows people to identify what the issues are. As Kyle mentioned again, at what is happening and been happening for years is that plaintiff will sue contractual party defendant number 1. Defendant number 1 then says, well, yeah, I might be contractually responsible to you, but there's all these other parties that were factually responsible to you, and they all owe you duties of care. That defendant then does is then join all these other parties across the page, so to speak, as defendants. The plaintiff is then put in the position of whether or not they want to seek to join them. I agree with Kyle that it's an unfortunate situation for a plaintiff, especially a plaintiff who's not insured or not a corporate plaintiff, that they're then forced to the situation of having to join all those people. But if you're acting for a defendant, as I regularly do, it's your obligation to make sure that in your counterclaim you identify each and every defendant that you say there's an apportionable claim against, you join them as a defendant to counterclaim, and you identify why they're liable to the plaintiff. Not liable to you, they may well be liable to you as the head contractor, but for Part 4AA purposes, you must identify the liability to the plaintiff. What I then do, in addition, especially in a situation where the liability to my client as the defendant is a contractual responsibility, I then also, bearing in mind what the Court of Appeal said in Quinnertz, you then also make a third-party claim against the parties that you identify as potentially being apportionable or concurrent wrongdoers. The reason you do that is to avoid the consequence that the court comes to the conclusion that, in fact, for whatever reason, they're not concurrent wrongdoers, and for whatever reason, the consequence is that there is no claim as between the plaintiff. For instance, there's no duty of care. You must make sure that if that is the situation and you are contractually responsible, that you then have a claim on a third-party basis for contribution. Now, I acknowledge readily that the Act says you can't have a claim for contribution where you have concurrent wrongdoers, but you must protect yourself on an alternative basis to say that, in fact, well, they're not concurrent wrongdoers, except that, then I seek contribution. So you have both a claim across the page, so to speak, as a counterclaim, and at the same time you have a claim going, a derivative claim, as a third-party proceeding. And this is the way that a lot of proceedings are now being done, so that you get yourself in a position where you can protect yourself, irrespective of whether what I say is the narrow interpretation of the Court of Appeal in Quinertz. Probably gather that I don't agree with it, but that's the situation. That's what we're stuck with at the moment. But from the point of view, ultimately, if everybody's insured, it doesn't really matter. The real problem comes where some of the defendants aren't insured, which is often the situation with subcontractors. Noting the time, and you may have a few questions, I'll just briefly touch on two other aspects, and they are the issues of costs. As Kyle mentioned, the difficulty you've got is that in a classical situation, plaintiff sues defendant number one. Defendant number one says, well, in fact, defendant number two and defendant number three should be joined. And then the plaintiff's in the invidious position of saying, well, I'm not sure I've got a cause of action, but alive to the decision in Saley, as well as the general view that if you don't join them, you can't get the damages. They then say, well, I'll join them, but I really think my claim's against you, defendant number one. Defendant number one will say, well, that's good, because if you join them as a plaintiff, and they're now defendants two and defendant three, if you lose, it means that you pay their costs, not me. People who find themselves in that position, I'd encourage to think very carefully about Bullock and Sanderson orders, because the allegation, if you get all the way through to trial, and ultimately your suspicion that defendant two and defendant three really didn't know you were duty of care, weren't responsible for the damage or whatever, it doesn't mean that you should just roll over on the issue of costs when you lose against them. What you should say to the court, and the court hasn't decided this yet, the only reason I joined them as a defendant is because defendant number one was saying that they owed me a duty of care. In those circumstances, I say to you, the court, what you ought to do is to say that defendant number one pay their costs on a Sanderson or Bullock basis. Now, the circumstances would need to be appropriate, but it's not a situation of simply saying, well, I lose against defendant two and three and therefore I have to pay the costs. The other point that we've referred to in the paper in relation to costs is there's this perception that if you have five defendants all equally responsible, it's 20% against each of them, that necessarily costs follow that 20%. There's a decision of VCAT where Senior Member Young did do that, but as Justice, and that's the decision that then went to Justice Byrne, that as Justice Byrne identified in Gunston and Lawley, that doesn't necessarily have to be the position. Even if it's 20%, 20%, 20% across the page, so to speak, it doesn't preclude you as the plaintiff's counsel from saying that, in fact, well, I don't care about the apportionment, you've got a discretion on costs, I think you should make costs against defendant two or defendant one or whatever, again, focusing on the person with the deep pockets. Now, again, the appropriate situation, that will be a question for the individual circumstances for the case, but just don't approach it on the basis we'll have a cost order of 20% against all of you. It might be, for instance, you might say it should be a cost order against all of them. You don't get 5 sets of costs, but you get cost orders against each of them, and then it's a question of who you recover against. The final point I want people to think about, bearing in mind the time, is the concept of contributory negligence, and it again arises from the issue of Quinertz. Posit this situation: you have a claim in contract between plaintiff and defendant, defendant number one. Defendant two and defendant three are defendants who owe duties of care to your client as the plaintiff. Now, and the allegation is that those duty of cares have been breached. Now, according to the High Court in Astley and Austrust, a claim for contributory negligence can't be levelled in circumstances where you've got a contract in place. I know I'm talking generally in saying that. But in relation to a claim in negligence, there's no reason why, for instance, in the example again of the Bricky example, the Bricky owed a duty of care, he caused a problem, caused loss and damage, but then there's something that the plaintiff did on its part that contributed to the problem in a contributing negligence sense. In those circumstances, even if, on one view, the Bricky and the head contractor caused the same damage, looking at what the Court of Appeal said, arguably the damage ultimately caused by them is not the same, because in the contractual sense it'll be the contractual measure. In the negligence sense it will not be the same because, for instance, there might be a 20% calculation of contributory negligence. Does that mean, and I'll just question mark this, does that mean if in any case where contributory negligence is raised, Part 4AA doesn't apply because it's not the same damage? Again, I encourage you to read Quinertz. But the corollary of that is that in relation to where you join all these parties saying there's duties of care, even though you may have a contractual responsibility, if there is an allegation, if there's a basis to sue to allege contributing negligence, you should seriously consider pleading that in your defence, even if you're responding to a contractual claim. Because the issue you want to raise in your document is to identify all the issues that the court needs to deal with, and if you don't raise it in your defence, when it comes to the issue of apportionment, you won't be able to say if nobody else has said it, well, in fact, in dealing with the issue of apportionment, there was contributing negligence. How that impacts upon the calculation of damage, people haven't thought about yet. But you do need to give very serious consideration, even if you're responding to a contractual claim, to an allegation of contributory negligence. Obviously, when you do it, you will encounter a pleading issue. You may well get a pleading challenge, but it's something at the moment, in my view, based upon what the Court of Appeal has said in Quinertz, you do need to give consideration to. Now, I've endeavoured to go through all these issues as fast as possible, given the time constraints. It's an area that I would encourage all lawyers involved in civil litigation to give very serious consideration to. In fact, in my view, it's one of the most important issues in all commercial litigation where generally there's more than one defendant who's potentially responsible. Conscious of the time, but I'm happy to answer any questions, or for that matter Kyle is as well, if people have got questions.
Thank you, Michael. A question at the back.
I have it's a matter where I've just been asked to advise on, and I may have to apply for an adjournment. Party A, which is a finance company, has sued my potential client for breach of a finance contract. The defence pleaded at the moment is that it's a collateral contract to what was the main contract, which is with a telco. That telco induced the contract, but that telco's now gone insolvent. The main contract with the telco has been terminated, and my client, the potential client, then terminated the contract with the finance company, and they said you can't do that, it's still light bound. Now, listening today, and I've only just had a quick look at the defence. My view is that there is a potential, particularly in this case, the telco's rep has turned up at my client's business, induced the potential client into signing the contract, just got a schedule, said sign here, sign here, sign here. The term, nothing's been explained. My client's understood it to be a collateral contract, and that's what they've acted on. My view is that, leaving aside whether you can, the issues, whether you can try and amend at a late stage and all that, which is entirely separate. If I was to now say to the client, look, I think you've actually got a defence and possible counterclaim under an apportionment, because it's really, in addition to the collateral contract argument, in that the plaintiff, in that my client has relied on the telco in entering into this finance contract, and therefore there is an apportionment issue. Would that be a correct interpretation of what you're saying?
Well, I'd certainly, it sounds, again, it sounds similar to the Quinertz situation, but it certainly raises issues of apportionment, yes, I agree. And certainly, obviously, you've got the problem that there's a trial date looming, and what the High Court said about that recently, but if you were talking just in theory, the answer is yes.
And there is a second point to that too, that is if the TPA applies, there's apportionment provisions within the Commonwealth legislation,
yes,
which which are different from Part 4 AA.
But the other issue with that is the telco's insolvent, so they can't be joined as a party.
They can't, but the individual agent can.
If they can be located. If they can't be located, we can still plead it. But obviously plead that the fact that the agent can't be located and the telco's insolvent, therefore can't join them.
As I heard somebody else say, the fact that you can't find him doesn't matter unless the person's dead. The fact that the company's insolvent, the Act covers that, but if the person can't be found, it's a different issue, because it's the same as the defendant who decides not to defend himself. You can still get apportionment against them.
And in fact, I don't even think under the Commonwealth legislation they have to be parties. It's under the Victorian legislation that they've got to be parties unless they're dead or insolvent. Can I just mention a couple of points that you should just put in the to be noted? Part 4 AA doesn't apply to arbitrations. Now, I say that categorically. If you look it up, there's some dissension about it, but we've had a recent case now in the full court in Tasmania in May, Aquagenics, where obiter, all the judges agreed that it didn't apply. And when you think about it carefully, it really can't apply. You have to work out which apportionment provisions might apply to your arbitration, because every state and the Commonwealth has got different provisions. And some require all the parties to be present in order for the apportionment to proceed. And you can't join parties to arbitrations who haven't agreed to be bound by the arbitration agreement. So that there's something inherently wrong about thinking that Part 4 or its equivalent could apply. The second point I'd like to raise is a matter arising out of Michael's address, and that is, even if a defendant thinks, well, there's a risk that Part 4 AA doesn't apply, so I will third party the parties that I'm also going to join as co-defendants. That isn't the end of Part 4 AA, because each of those joined third parties has to consider whether Part 4 AA might have application in relation to the first defendant's claim against him. Here you've got a plaintiff against defendant. The defendant says, hey, it's not just me, I'm just first defendant. There are 6 other defendants, so now there's 7 defendants. But also, in case I, the first defendant, am wrong, I'll join those 6 other defendants as 6 third parties, the second tier, if I can call it that. Each of those third parties has to consider whether the first defendant's claim against it could be an apportionable claim. And it then has to join each of those joined other defendants, and possibly the plaintiff, as co-defendants at a second tier level, and so on. That happened 3 times in Aquatech, and it gets to be absolutely impossible. Any other questions? One over here.
In relation to the breadth of the provisions, any experience in intellectual property, such as copyright infringement or passing off?
Passing any experience?
Or cases?
At the moment, there are, not to my knowledge, but the cases are rapidly expanding. I would have... breach of federal legislation...
I don't think it applies to the copyright. I'm not sure that it applies to the Copyright Act.
No.
It applies to corporations law, I think.
No, well, that's Dartberg was about that. So.
Yeah, there are certain Commonwealth provisions to which it applies specifically, but otherwise it hasn't got a general application.
But passing off being a tort, there's no reason why it wouldn't apply to that in appropriate circumstances, because that, when you think about the nature of passing off, that could involve an allegation of failure to take reasonable care. So
depending on how the evidence turned out.
So the answer is potentially yes, and certainly should give consideration to it, especially if there's more than one party involved in the passing off.
Any other questions? Are you two going to be around for 10 minutes? If anybody? Both Kyle and Michael are going to be around for 10 minutes or so, so if you decide that you want to stay on and just speak one-to-one, by all means do. Otherwise, thank you very much indeed for your attendance.